perhaps make some general conclusions and look at the national perspective as well. And to do that, we have four really excellent speakers. We're really honored to have them. And we only have an hour, but I think we have a lot of material to crowd in. I think we can do it. What I wanted to do is first start with Representative Stephanie Pitcher. All the bios of the speakers, by the way, including Representative Pitcher, are in your package of bio speakers, and we'll be giving you a brief snippet of them as they speak. In Utah, as Representative Pitcher will say, will tell us, they started well, but it's always maybe 2 steps forward and 1 step back. And I think we're now in a backward mode, as Representative Pitcher informed me earlier this morning. So let me start with Representative Pitcher to tell us what's going on in Utah.
Sure. Thank you so much for having me. So I'll just start out. My name is Stephanie Pitcher. I was elected to the Utah House of Representatives in 2018. I've just started serving my second term. It's my third legislative session. And 2 years ago, well, I guess a year ago, in 2020, I introduced a bill in Utah that was a very comprehensive bail reform measure. I should preface this by saying that I work as a felony prosecutor in a county just north of Salt Lake, and have a lot of experience with sort of the practical implications of bail reform and how the pretrial system operates in our state. So my 2020 bill was numbered HB 206, introduced a number of best practice recommendations recognized by our Utah Judicial Council, as well as national organizations such as the American Bar Association, the Uniform Council on State Laws, the National Association for Pretrial Practices, among many others. Essentially what it did was it stated that when imposing pretrial conditions, a judge should impose the least restrictive, reasonably available conditions to the judge that are necessary to meet the pretrial risk presented. And among the factors that should be considered would be the defendant's public safety risk to witnesses or any victims, the individual's flight risk, and the risk of obstructing the criminal justice process. So those were the factors that needed to be included. We also included in Utah Code a long list of other factors that could be imposed apart from monetary bail. So this included things like an ankle monitor, random drug and alcohol testing, a curfew, whatever conditions would be appropriate given, again, the risk that individual presented. And then finally, it also created a presumption of detention for individuals charged with first-degree felony offenses. So the idea was sort of, if we're going to impose the least restrictive conditions, and I should also mention there was a presumption of OR release, or release on your own recognizance. So the inquiry starts presuming that someone should be released, and then if there are additional risks that individual poses, the judge would then consider those risks. And then finally, as I said, we created this presumption of detention for individuals charged with first-degree felonies, but it is, of course, a rebuttable presumption of detention, and a defense attorney would need to show that there are lesser restrictive conditions available to meet the pretrial risk. And if they can show that beyond a preponderance of the evidence, then the judge should impose those conditions. We also said that if a financial condition is imposed, that a judge should consider an individual's ability to pay the amount set. That provision was really a response to the overwhelming number of lawsuits that we have seen across the country. Nothing in Utah or the 10th Circuit yet, at least to my knowledge, but certainly in other places across the country, stating that it is an unconstitutional deprivation of an individual's due process and equal protection rights to impose a financial condition without at least considering their ability to pay. So all of those things were imposed by way of HB 206. That bill went into effect in October of 2020. It was in effect for about 5 months until the issue came back up in front of the Utah legislature this session. We just got out of our legislative session about 2 weeks ago. And in those 5 months, shortly after the bill went into effect, we got a lot of pushback from sheriffs and certainly the bail industry, although we found that the bail industry was sort of curiously quiet during the legislative session. And I think that there were some strategy reasons for that. But certainly some discomfort from our sheriffs with regards to the types of conditions that were imposed. The sheriffs throughout this process compiled a binder of about 66 cases that they said illustrate why HB 206 was not working. When I finally got a hold of that binder, I went through each of their conditions, and I found that by their own self-selected cases, 80% of the individuals were actually compliant with their pretrial release conditions, which was a higher compliance rate than a comparable group of individuals prior to HB 206 going into effect. So to make a long story short, I did not find that there were many compelling data or even anecdotal stories to support the narrative that our bail reform efforts weren't working. However, the process became extremely political, and unfortunately, that bill was repealed this past session. Our governor actually just signed the repeal bill into Utah law yesterday. And I'm happy to go over more of what that entailed, but for now, I'll just provide that brief overview.
We obviously want to know what the next steps are going to be, but before we get into a conversation about that, Carmen Brooks is the Deputy Public Defender in the Colorado State Public Defender's Colorado Springs office. So let's hear from Carmen about what's going on in Colorado.
Good afternoon, I guess, or morning, depending where you're at. So as a line public defender, I honestly have not been too involved in the political aspects of bail reform. I see firsthand how it impacts my clients and how the bulk of my clients as a public defender and during my previous work as a private attorney, bail impacts the poor. There's no other way to say it. In Colorado, over the last 2 years, we've seen a number of movements. Bond was ended for money bond was ended for low-level offenses. That was HB 19-1225. There is now a statewide court reminder in place. So oftentimes when we see failures to appear, that's most of the time poor or indigent people who have issues with transportation or cannot afford a phone, or with the COVID going on right now and all of the virtual courts, they don't have access to free Wi-Fi or even Wi-Fi at home or a smartphone or a tablet or whatever have you in order to appear virtually. And so when we talk about failures to appear, the most important thing for a lot of our indigent clients and a lot of our clients who suffer from any number of side effects of poverty is just a simple reminder. And so there was a bill passed in 2019 that now there is a statewide court reminder system that any county can tap into if they're unable to set up their own. One of the things that we see with bail is simply a lack of data. Jails don't seem to like to provide data. That's something that we're seeing more and more of, especially in light of COVID and some of the lawsuits we've seen in Colorado, specifically El Paso County, which is a county I work in, and Weld County, which is north of Denver, Fort Collins area. And so there was a bill that jails are now mandated to collect data so we can keep track of really what's happening, really why people are being held pre-trial. There's also a bill that was passed in 2019 ordering prompt release from jail. So no more of this, you post bail and you might not get out for a day or two. It's supposed to happen within 4 hours. I can tell you from personal experience with my clients, that doesn't happen within 4 hours, but that is a bill that was happened. Since COVID, we have seen, as I think I caught at the tail end of the justice talking about that, the numbers have gone down in our jail significantly, almost 50%. I believe statewide it's 46%. And because we have seen that decrease and not seen a substantial increase in crimes at the same time, we now have a bill that's being proposed, Senate Bill 2162, that tries to codify a lot of the things that happened during COVID in order to reduce the jail population. And so with that bill, they're trying to increase, right, the presumption for the lowest level of supervision that has been codified in Colorado state law for quite a while. And so there are a lot of political forces trying to do that. Obviously, I'll agree with Representative Pritchard that the bail industry definitely has a very, very clear stake in how this all wraps up. But ultimately, when we look at bail and we look at the reasons behind bail and we look at the way that a person is assessed as to whether or not bail should be set, there are a lot of things that have to be ironed out in terms of racism in terms of presumptions against homeless people or against indigent people, some of the things that they simply can't afford. The final thing I'll say is there's been studying into the tool that's used to provide a risk assessment for someone in terms of will they come back to court and are they a danger to the community. The numbers in that study of both the original version of the test and the amended version of the test show that by large, racism and socioeconomic status are what are really impacting those people who are held, right? So for example, Denver is 10% African American. It's 30%, the jails are 30% pretrial detention African American people, right? And so when we look at these and we look at stuff like owning your home, right, not owning your home is a stack against you. Not contributing to payments is a strike against you. Your first arrest being under the age of 19. And studies are clear, numbers are clear. By and large, that is going to happen for Black and Brown Native American populations. That's a huge strike against you, depending on which tool you're looking at. And so we have a lot of forces converging in Colorado to try to make substantive change in terms of what bail looks like going forward.
Thank you, Carmen. Sarah Hawkins is the Chief Deputy Public Defender of the Clark County, Nevada Public Defender's Office. And she's also the President of the Nevada Attorneys for Criminal Justice. So let's hear what the situation is in Nevada. Sarah?
I'm going to say morning because it's morning here. So good morning, everybody. Thank you first and foremost for having me on. Bail has been a bit of a roller coaster here in Nevada over the last couple of years. I'll preface my comments by saying that we have a biennial legislature. I think we're one of 4 states that is a biennial legislature holdout. And why that's important to this discussion is that, we don't have the opportunity necessarily to strike legislatively while the iron is hot. So a lot of what we accomplish has to be done through case law, sometimes in the in-between times. Before April of 2020, the essential process was for an arrestee to come in, have an initial appearance within 72 hours, and the judge would set a quote unquote automatic scheduled bail based on what the charge was. And then the defense and prosecution had the opportunity to argue for a deviation, either up or down. They abolished bail schedules for the most part. There's still some standard bail set by the jail when folks immediately come into custody. But a case came out in April of 2020, Valdez Jimenez versus the 8th Judicial District Court, that had a substantial impact on how release determinations are made in the state of Nevada. Really, went a long way towards bringing Nevada into compliance with federal law in terms of beginning with the presumption of innocence, requiring the state to make a showing for, justifying the deprivation of liberty. So essentially, now what happens is an arrestee comes in, gets in front of a judge, and the prosecutor has to say, hey, I'm seeking to detain. And once there is a detention request, the prosecutor has the burden to prove by a measure of clear and convincing evidence that the person is either a danger to the community or will not return to court. There are a list of statutory factors that have to be considered in the judge rendering that determination. If the judge finds detention is appropriate, then the conversation moves to what requirements or conditions is the judge going to impose. Is it money bail? Finances have to be required now pursuant to this case. Ability to pay has to be considered. So we provide some supplemental information, and the judge hopefully meets out the least restrictive means so that folks can get out of custody and address their case. that way. The problem that we're running into here from my perspective, and I think that there are folks that would agree with me, is that the district attorneys, at least in Clark County, really don't like this. They don't like the burden having shifted to them. That's pretty typical. I'm seeing a little smile on Carmen's face. She knows what I'm talking about. You would think you took a rattle from a toddler. So they don't like this. So they're arguing about this in a different way. And what they're trying to do is circumvent the application of this case. There's no statute, that codifies the requirements in this case. So they're treating it as if it's not precedential or applicable. And we have elected judges. So those judges are inclined to take a law and order stance in order to maintain their police and police union donations and prosecutorial donations, because that voting block gets them in every time. DA gives them an excuse, and then unreasonable bail is set, which is the opposite of what this case was trying to accomplish. There are courtrooms in which this Valdez-Jimenez procedure is being executed properly, and it has resulted in an increase of releases. Typically, that increase is reflected most in the fact that we have more people on house arrest in Clark County than we ever had. Judges still want to keep an eye on folks, even if they think they're okay to be in the community. That house arrest bracelet is the thing that makes them feel better about it. So we're running out of house arrest bracelets. It's a good and bad problem to have. But what we need is to codify this. And I'm incredibly concerned because we're in the middle of a legislative session right now. So it's a very busy time for Nevada, trying to stuff 2 years, 400 years worth of police reform into a single session. So that's going to be a pretty tall ask here in Nevada. A little bit of love because Nevada, for the first time this year, got a set of criminal procedural rules, and those criminal procedural rules do contain some of the Valdez case procedural language. So I'm hoping that is another resource that we can rely on to really sort of impose this and put into practice this least restrictive means idea, because it is in our clients' best interests. It's easier for us as attorneys in terms of strategy and preparation, and it honors the presumption of innocence, which frequently is not at the forefront of what happens in the criminal justice system. So I'll leave it there.
I love that. Thank you, Sarah. I love that image of taking a rattler from a toddler. I don't know if prosecutors would feel complimented by that, but there certainly are prosecutors elsewhere in the U.S. Who are on side. I mean, whether you're looking at San Francisco, you're looking at New York or Boston, there are lots of prosecutors who do seem to think and agree with the need for bail reform. Representative Pitcher is obviously one of them in this region, but I wonder if, moving to Professor Fradella, if you can give us some sense of how what's happening in the region fits into the national perspective. I mean, is the Southwest well behind in terms of climate, other places in the country, or is there something we're missing that's happening here that's not happening elsewhere?
Well, good morning, Stephen. Thanks to my fellow panelists for sharing what's going on in their states. I think in the Southwest, we are part of the national trend where many states are looking at bail reform, but the bail reform that we've actually taken in most of the Southwestern states is not as progressive as the bail reform efforts that we've seen in other states. For example, New York probably enacted the most significant bail reform effort, but it lasted all of 3 months and was repealed, just like in Utah, 5 months, and we saw repeal.
Well, actually amended, so it still exists, but there are fewer offenses.
Both scaled back such that the meaningful reforms are no longer there. Yes. So Illinois, just last week, the governor signed a bill enacted by the state legislature that truly abolished money bail. And I think that is, starting with the conclusion, I think where we really need to go. Money bail punishes poverty, right? People are being held in bail not because they are a danger to the community, but rather because they can't afford to post the bail that has been ordered. Sometimes that is individualized. Sometimes it's because of bail schedules, which are constitutionally suspect. If we look at, for example, data from the Bureau of Justice Statistics from 2018, we know that we had just shy of 739,000 people being held in jails, 2/3 of whom were pretrial detainees. That's a remarkable statistic, right? 2/3 of the people are there because they can't afford the bail that's been ordered in their case. We don't have official data from the federal government since 2018, but we do have a study from the Vera Institute of Justice in New York that looked at the most recent data available, 2019, where jail populations increased to just shy of 760,000 people. And it was the remarkable statistic, 1 in 5 people were serving custodial sentences, meaning 80% of the people who were being held in our nation's jails were there because they could not afford to pay or post the bail that had been ordered for them. And there's an interesting study that an economist did in about 3 or 4 years ago that showed even when bail is set at a comparably low level, let's say $500 or less, as it is in roughly a third of all non-felony cases, only 15% of defendants can actually come up with the money to avoid jail. Well, $500 is a lot of money for somebody who is living paycheck to paycheck or doesn't have one. And so that's one of the things that sort of led some courts to invalidate bail schedules. But as I think every one of the panelists has touched on today, this is a highly political issue. But where we're seeing a convergence from people on the left and people on the right is when we look at the cost of what this system is doing nationally. We spend $38 million a day. That's $14 billion a year to incarcerate pretrial detainees in our nation's jails. That's enough money to provide shelter and services for the roughly 50,000 homeless veterans in the United States, to hire 300,000 firefighters, 250,000 elementary school teachers, provide free or reduced lunches for 31 million hungry children. So there's this recognition, I think, that the amount of money that we're spending to incarcerate people, especially those who don't pose a public safety risk, just because they can't afford to post bail in their case, is something that, in these times when budgets are tight, especially given what has happened fiscally in the age of the pandemic, we're seeing left and right starting to say, maybe there's, things that we can do that would reduce the cost while serving public safety, and doing so in a way that helps reduce the disparate impact. Ms. Brooks, pointed out the disparate impact in Denver on African-American communities. It is that way nationwide, where pretrial populations are disproportionately Black and Hispanic, and that rate has doubled over the last 15 years. So we see huge problems with the way that pretrial justice is being administered in the United States. And one of the solutions that many states have done, and I think Ms. Brooks touched on this in Colorado, is that there are now these risk assessment tools that are designed to say, oh, this person is low risk, we don't need to put money bail, or at least not a substantial amount of money bail on those people. And I guess I want to put in a pitch to say this is a misplaced solution. True bail reform should not depend on risk assessment instruments because they are racially biased. They oversample statistically From historical data, we know that that means that people of color and people of low socioeconomic means are over-policed in their neighborhoods, and they're racially targeted when they're out of their neighborhoods. And so you get this ratchet effect, that's the words of law professor Bernard Harcourt, where if you start using these algorithms, as all of these risk assessment instruments do, that look really objective on paper, they're using all of this racialized data in a way that will perpetuate more racial injustice. So I think the solution is to do what Washington, D.C. did in the late 1960s and has worked incredibly well for 50 years, which is abandon money bail, don't use risk assessment instruments, instead assess people's needs, give them pretrial services, and mirror some of the things that some of the other panelists have talked about in their jurisdictions about court notification programs, which are the single most effective way of reducing failures to appeal.
Thank you, Professor. A lot of judges don't like the risk assessment tools either because they remove their ability to make their own decisions, that's a debate if we can get a chance, we'll talk about it further in this panel. But let me go back to the cost issue. That's certainly the plane on which a lot of the debate or the discussion about bail reform has moved, particularly in areas where people are conflicted over tough on crime or soft on crime measures. And I'm wondering whether our speakers from the three states think that would be an effective way to get back at the issue. Maybe let me start with Representative Pitcher, who now has to think about what the next steps are going to be in Utah. Is cost a possible way of getting the issue back on the table in a useful way?
I think so. I think during the advocacy process for HB 206 in 2020, costs certainly came up as a factor of consideration. We are an overwhelmingly Republican majority legislature in Utah, and so talking sort of from a fiscal savings standpoint resonates with a lot of my legislative colleagues. But honestly, I think the more relevant point of conversation, at least, always have to be part of the conversation. And I think on my end, or those who are.
We seem to have an audio problem. Stephanie, can you check your mic? We'll just check the. 1 second. Yeah, there you are. We seem to have an issue. Let's see if we can fix that. Maybe go. Sorry, Stephanie, we missed you. So maybe we'll try to get that sound back, and maybe move to Carmen next about the salience of economic issues in terms of bail reform.
So I think the economic savings has been a large part of why we are seeing SB 2162, and we're seeing a number of other propositions come up this legislative session in Colorado. I mean, if we, to put a figure on it, right? If we consider that the average per day cost of incarceration to the state is $100, and then we consider that during the months of March to May of 2020, the jail population was down around 6,000. And so if we consider that cost alone, right, over those 3 months is over 54 million, right? And so when we consider numbers like that, it's obviously, especially given all the cuts that we're having to make to social services and to employees in the state budget and rec centers and other things that we know go to decrease criminality, it's definitely something that I know is behind, right? The economic impact of every legislative bill is considered. So I think it's something that's definitely behind the push we're seeing now.
Sarah, is that effective in your part of the world as well?
Yeah, I think I agree with that. And I think the climate right now, at least from a legislative perspective, because of COVID, everybody is very budget focused.
Right.
And I think I mean, in Nevada in particular took a massive, massive hit. So those things that have cost saving measures, I think have the opportunity to sort of court folks that wouldn't necessarily consider it, or were sort of on the fence and then see the savings and then start, and can sort of get behind legislation like that from a fiscally conservative perspective. And I think that's good. I mean, those things don't always line up and can cause some partisan conflict over criminal justice issues, but I think that has the potential to be very helpful here, especially in this environment, this post-COVID, in COVID, who knows when it's ending environment.
Thanks, sir. Let me go back to Representative Pitcher. If you can unmute yourself, let's see if the sound works now.
Okay, is this any better?
Yes, it is. We can hear you. At least I think it is.
Okay. Sorry about that. My connection here is a little poor, but I just switched. So I was just saying that absolutely is a very relevant part of the main arguments against HB 206 this past session were more from a public safety standpoint. But, I think it's certainly compelling that when we look at our own data here in Utah, it costs us between $80 and $100 a day to house someone in any of our county jails, but it costs just $7 to $9 to have them out on pretrial supervision. So from a fiscal standpoint, it's certainly the more responsible option. And we also know that data shows that low-risk individuals who spend just a day or two incarcerated, the risk of recidivism actually goes up. I mean, they lose their jobs, they lose their ties to the community, their ability to support their family. All of these things operate in a negative way on someone who, in Utah at least, it's my opinion that we just became systemically lazy with regards to our pretrial practices. I mean, we just took a level of offense. We operated off of a traditional bail schedule. We took a level.
Sorry, all. I think we've lost
offense. There was an associated amount charged, and that was it, regardless of that individual's risk to the community. And it's quite unfortunate that this repeal bill passed because there's a lot of What's that?
We're still having problems hearing you. I think hasn't quite been resolved. It's definitely a bad connection. Let's keep working on it. We have a couple of questions.
Sorry, I didn't mean to interrupt. I was just saying there's a lot of uncertainty now on our end about how this is going to operate moving forward. It's not a good use of taxpayer dollars.
Okay, let me move to. We have a bunch of questions from journalists in the audience. The couple for Representative Pitcher, but let me go first to Chandra Whitfield, who asked whether one or all of you, in fact, can speak to the role and the impact of the for-profit bond industry, which she estimates is about $2 billion, which is probably not far off. And many of you have mentioned that as a factor in the debates. Some of the opposition obviously has not been public, but behind the scenes and lobbying behind legislatures. How strong is the bail industry right now in the region? In other parts of the country, it's not as strong as it used to be. I can say that. Who wants to take that on first, or perhaps Professor Fradella wants to?
Sure. Well, the number is correct. In fact, best estimates are that it's about $2.4 billion a year annually in commercial bail. And the really interesting thing about the commercial bail industry, it looks like there's just a whole bunch of small mom and pop independent bail bonds companies. But what's kind of interesting about it, there are really about 9 major underwriters of bail bonds in the United States, and forfeiture is incredibly rare. Right, as low as 1.7% of all bail bonds get forfeited. In the highest jurisdictions, it's 12%. But that's a remarkable thing when you think about revenues versus expenditures. You compare that, for example, auto loans, they pay out between 40 and 60% of premiums on auto claim losses, whereas at maximum, the underwriters of these commercial bail bonds are paying out roughly 12% max, and usually as low as 2%. So you've got these 25,000 individual bail companies being underwritten by these major multinational insurance companies that sort of operate under the radar, and they throw a lot of money at anti-bail reform efforts to eliminate money bond because it's so profitable for them.
Thanks. You'll see, Kenny has just put in the chat box report from the LBS Market Research Company on the bail bond industry, which provides some facts and figures about how powerful they are. But the question, I think, maybe for both Sarah and Carmen, is whether they're so strong that, you know, it's impossible to fight against them, or are there ways to get around it? I mean, are you guys feeling under the gun against these really powerful giants of the industry in the same way that we have for-profit prisons, that we have the NRA as a major lobbying group? Do they represent the same threat in this region to bail reform as these other organizations do? Who wants to take that first? Maybe Carmen?
So again, as a line public defender, I am not front and center for a lot of these political discussions. But what I will say is, because of the convergence of political interest, right? So we have a very conservative judge out of Mesa County. We have the typical, not typical, I shouldn't say, the lobbyist who's been working on behalf of the Colorado Criminal Defense Bar, the Public Defender's Office, our alternate defense counsel, which is our conflict panel in Colorado, is a statewide agency. And so they have become strange bedfellows, for lack of a better phrase. And a lot of that has to do with the way that bail bonds take advantage of poor people, right? The stories I could tell you, right? Like, I understand we're on limited time, but the stories I could tell you. So I think that in Colorado, we're seeing a similar political push. There was a political push in, 2008, 2009, to really legislate check cashing places because of the way that they would take advantage of indigent people. But understanding that for people who live paycheck to paycheck, that still remained a vital service in some ways, right? And so there was a big push to legislate and regulate those types of businesses. And I think we're seeing a similar convergence around bail bonds because of what the numbers in the study show in terms of bond does not increase the likelihood to report. In fact, people who are released on personal recognizance bonds, is what we call them in Colorado, are more likely to report than people who are on cash bail, right? And so when we see that, and then we see the reminding system, set up, then everyone is able to converge around that. And then, as Sarah was saying earlier, Colorado, they need every dime they can get. And so if we can see that same kind of reduction in terms of the jail population, right, that savings that we saw over 2 months or 3 months, right, we multiply that by 4, right, and you have a savings that's over $200 million to the state.
I want to put together 2 questions from our journalists that are kind of connected. One is from Felicia Fonseca of the Associated Press, who asks whether there's any state that stands out in most need of bail reform, which is kind of a leading question. And from Jeremy Duda, specifically to Professor Fradella, who asks about Arizona, is that what steps are being taken on bail reform in Arizona, and what changes would you like to see, and the prospects for that actually succeeding? And we can expand on that. I guess we can look at the other states in the region as well. Is anybody doing better than anybody else, or for that matter, worse?
Well, let me start by echoing a comment I believe Ms. Brooks made earlier, and that is data are hard to come by, right? Jails don't always report these sorts of things. I think Ms. Hawkins also commented on that in her state. And even in states that have undertaken reform, it's hard to do any kind of meaningful analysis because of COVID. So many of these reforms went into effect in the last 2 years, and then the pandemic hit. And so you see this tremendous drop in jail and prison populations. And we don't know what to make of crime rates. They're down in most places, they're up in some others. So it's really hard to sort of get at who's doing particularly well right now.
It's interesting.
That's an open question. There are, however, directly to her question, who's doing particularly poorly? The Pretrial Justice Institute in 2017 issued a report card ranking all of the 50 states. You can go to the Pretrial Justice Institute's website and download that report card where they literally use grades like A through F. And you'll see there's a lot of states, Alabama, for example, that has an F, and they explain why. These are states where money bail is just routinely set at levels that nonviolent, low-level offenders cannot afford, clogging up jails at taxpayer expense and further perpetuating a cycle of poverty and crime.
So the pandemic is always part of any discussion right now about criminal justice reform. But in fact, many people are saying that what the pandemic has shown is the populations of jails in particular has decreased, recidivism has gone down, and people are saying this is a living example of the fact that if you do change the way we've done things in the past, you won't get the uptick in crime or criminality that most people assumed would happen if you don't put people in jail for the kinds of minor offenses or relatively minor offenses they have been put in jail for up until now. Maybe just to go back to Sarah first, I mean, what kind of effect has that had, the pandemic in particular had on thinking about bail reform and pretrial detention reform? And then I'll go to the other folks as well to see what their answer might be.
Well, I mean, at the outset of this, my first concern as a public defender is how do I get people out? I know from my own experience that the anecdotal experience with clients over many years that the healthcare in the local jail is subpar. You know, it's no place we would ever seek out treatment. There is no real such thing as preventative treatment. And typically when emergencies like this happen, the jail will be the last to respond and get protections in place. Simultaneously talking to clients made it very, very clear that the protections that were being recommended nationwide were not being implemented. So getting them out was the first concern. Our judges were not very friendly to the idea that a dangerous and deadly pandemic in a small closed space where officers are bringing germs in and out every day was a reason to set somebody out of custody, even on monitoring, to give them an opportunity to socially distance, self-isolate, and or when the time comes, get vaccinated. So that health aspect of it has been incredibly unfair. I have had some judges factor that in, especially where there are high-risk patients with documentable risk factors, at least consider that. I'm not going to say they actually released them, not in my cases, and maybe another attorney in my jurisdiction has had a different experience. You know, but for the most part, they're not getting released, and the conditions in custody are not better. In terms of arrest rates, there is an order in place. It's an agreement essentially between the district attorney and the court. That officers are essentially not going to charge low-level non-violent offenses to avoid bringing more people into custody than they need to. And then that is still in effect. The degree to which it is utilized it is another question. I think they could probably be doing more with that order, but you know, that is what it is. You know, but for the most part, the most problematic thing is that I have a bunch of folks presumed innocent sitting in custody with their trials not going forward and judges not considering that to let them out, right? Not only is there's this danger in custody from a deadly disease, but that trial you invoked your right to, statutory state right to have in 60 days, boy, that's not going anywhere because we're not getting juries in here. We are now, we've only had, you know, a trickle of trials begin in the past month in terms of the number of folks who are invoked to proceed to trial and are in custody. There's a list of over 150 people that have to go through 2 courtrooms to have their trials. And then on top of that, there's everyone that has waived their right to a 60-day right who is still in custody. And going in and readdressing custody status and saying something like, Judge, how long is too long to be in custody, presumed innocent, before a trial, before you let someone out? You know, I'm me, so that's like the day after you get arrested. But there's a reasonable time before, you know, where we need to sort of draw a line and say, we're not going to cage people who haven't been convicted when there's a pandemic beyond their control that's making, you know, procedural process impossible. So that to me is the most major concern. There's a whole host of them, but my folks that are over there just sitting, waiting for trial, they're not getting out. And that's the COVID in that context is absolutely not being considered a reason to release.
Thank you, Sarah. So I see we have Stephanie Pitcher back. So I want to bring her into the conversations about, first of all, about the impact of COVID and the pandemic on thinking about reforming not only just obviously bail, but other aspects of criminal justice procedure. We're going to be looking at that later on in this seminar series, but maybe we can start the conversation now. And we also do have a specific question for Representative Pitcher, which takes us back to the question of the algorithms that Professor Fradella mentioned earlier. And this is from Tim Igo, who asks, as a legislator, how much do you scrutinize the algorithms that have been adopted that were developed by private companies to assess the safety issues and flight risks? And would you characterize the use of them as a welcome development, or, as Professor Fradella indicated, too full of bias to be really useful? And I want to get Carmen Brooks on this as well, and maybe Professor Fradella can chime in at the end.
Yes, I'm very sorry about what happened. I hope my internet's okay right now.
The perils of Zoom, so don't worry.
Yeah. So regarding algorithms and pretrial safety risk assessments, we were able to sort of successfully steer clear of that conversation. And, you know, a lot of what I'll say sort of comes from a strategy standpoint as a Democratic legislator trying to pass these reforms. But I found the conversations involving pretrial safety risk assessments, PSAs, to not be helpful. It was just another thing that was sort of confusing to a lot of my legislative colleagues. And so the way that I framed our bail reform conversation was, look, PSAs deal with how we assess risk, right? My bill addresses what we do once we have assessed someone's risk. So once we've determined what those risk factors are, my bill deals with what we then do with them next. And I really wanted to parse that out because my fear was that if we got into the pros and cons of the PSAs, it was just another point of confusion in an area that is already very specialized. And it's hard for a lot of my legislative colleagues to really understand and process these issues. So for the most part, we steered clear of PSAs. Moving forward, that may be a topic of conversation. I myself would need to do a little bit of research. I mean, I've heard a lot about PSAs. I'd have to really think about what my own policy standpoint would be. But moving forward in the conversation of bail reform, I'd like to keep those two issues separate.
And do you want to talk a little bit about the impact of the pandemic on the reform process?
Yeah, I mean, to the extent that COVID sort of impacted the repeal effort, which again passed just a couple weeks ago, there were a number of things that the Utah sheriffs were blaming on bail reform that actually had nothing to do with bail reform. One of those things was the issuance of what they're calling penny warrants in my state. And so what judges are doing, and this was a direct result of COVID, is if someone fails to appear and that judge deems that person not enough of a risk that they need to be taken into custody, what they do then is they issue a penny warrant. And it's basically, for lack of a better way, to send a notification to a defendant. But the intent is that if law enforcement encounters this individual on the street moving forward, they see a penny warrant, which is a signal to law enforcement that they need to give that person a heads up that they have court in 3 weeks or whenever it is. So the issuance of a penny amount on the warrant is nothing more than a signal to tell law enforcement, please give them notice. But law enforcement, not fully understanding what those entail, have interpreted it as something that has stemmed from bail reform. So that's one way that COVID has sort of impacted the conversations around bail reform. Beyond that, another thing I would say is that in our state, we're seeing a surge of domestic violence cases right now. And our preliminary data on HB 206 and bail reform has shown that riskier individuals are being detained at higher numbers and low-risk individuals are being released at higher numbers. And so how does COVID play into all of this? I think one very obvious way is that with a rise of domestic violence cases in our state, HB 206 was doing its job in terms of detaining these more dangerous individuals. And unfortunately, with the repeal, we're going to lose that process.
Lose the momentum, in other words, I guess.
Yeah.
Carmen, over to you about both the pandemic and algorithms.
So I think we have to acknowledge like two elephants in the room when we talk about risk assessment tools and bail reform, right? When we look at historically, right, the reason for bail and coming out of the southern states, that was one more way, right, to ensure that some of the lost labor, because we see prisons in the South, right, Angola, and those of that nature that still have the farm system, still have the labor system, right? We have firefighters in California who are inmates who are working off their time, putting their lives at great risk, right? So when we look at bail reform, we also have to consider one of the big reasons behind it in terms of forcing people to remain indentured, right, enslaved, right, depending on who you're talking to, in order to exploit their labor. So I think we have to acknowledge that in any conversation we're having about bail reform, right, is what was the underlying purpose of it in the first place. I think the second elephant that we have to acknowledge in the room when we're talking about risk assessment tools is we talk about standardized tests, but standardized for whom? Because when we look at tests like the SAT, the ACT, when we look at tests like the bar exam, when we look at board exams for medical professionals, right? Standardized for whom, right? They are barriers to entry, and that barrier is set on a standard, right? And that standard tends to be a white man of a certain socioeconomic status, right? It's the example that always comes to mind is there's a story of a little boy who got all of these questions wrong in a standardized test, a little black boy. And it was because he would look at, there was a picture and then it was, what is this? He circled sailboat, but because it had 3 masts, it was a catamaran, right? And what average, right, young child is going to know the difference between a sailboat and a catamaran, right? And so I think the thing that we have to consider when we look at these standardized assessment tools is standardized for whom? Because looking at the most recent, I should say, the most recent version of the Colorado pretrial assessment tool was done by academics, right? So it wasn't done by a private industry, right? It was done by academics at the University of Northern Colorado. And so even though we have academics doing this, right? There are unconscious biases, both of these academics, and I've met them. This is not pejorative against them, but they happen to be white. And so when we look at these assessment tools and we start to think that through, that is one of the reasons why they do not, right, treat people equally. And if we're talking about people's rights, right, they have a constitutional right, equal protection clause, to be treated equally, regardless of their income, regardless of their race, regardless of their background. Right. And so it's stuff like, with the most recent assessment tool, right, and the higher your points, the higher your risk, right? And so if you do not own a house, that's 4 points against you. If you are not paying rent or paying towards a mortgage, that is 9 points against you, right? When we look at the older version and we look at the age at first arrest, if you were 19 years or younger, that's 15 points against you. And again, going back to the professor's points about over policing, right? We have, and the studies are clear, right? We have Black and brown boys who are contacted double digits of times by police before they even hit 10, 12, 15. And, when we talk about arrests, what are they being arrested for? If we're talking about a true risk assessment, right? Risk to the community, violent risk to the community, right? Are we talking about this is a child that's been arrested for shoplifting? Or are we talking about this is a child that's been arrested for assault, right? And then there's all sorts of socioeconomics and sociology that goes into all of that, right? So I think we have to address the elephants in the room in order to really assess if these assessments can be unbiased. I simply don't think they can.
So thank you, Carmen. So many of you have answered some of the questions that the journalists have already posed, but let me give Professor Fradella the last word on this and some of the other questions we're talking about. I mean, I'm not an advocate one way or the other on risk assessment tools, but there are many different kinds of risk assessment tools, and there are some, according to some scientific evidence, that are better than others. So I'm not sure whether we're throwing out all of the risk assessment tools or the concept of them, or just asking for them to be a lot more sophisticated, if it's possible, to be used, because the reason they were put in the first place is to reduce the ability of judges to use their own biases and prevent people from release when they should be released. So, but I'm not making the point of pro or con. I'm just pointing out that there are some people who say that some risk assessment tools are at least the start of using science to determine whether people should be put in prison before trial or be held before trial or not. So Professor Fradella, over to you.
We've masked racism in the cloak of science. Yes, there are some risk assessment instruments that are better than others. In fact, most of the risk assessment instruments that are out there were never even designed for use pre-trial. They were designed to help classify people who have been convicted of a crime at a trial to place them in a particular security level in prison. And we just took some questions from that and went, oh, well, we can make bail assessments using those. No, we can't. They're very different. They have different norms. They have not been validated for the populations on which they've been used. For the ones that are targeted at pretrial, there is no escaping the fact that the algorithms, some of which are completely masked, right, where we don't know how they're even calculated, but even for the ones that are transparent, they use data that simply perpetuates the biases that are already in the system, which has led researchers from MIT, Harvard, Princeton, NYU, UC Berkeley, Columbia, and the Algorithmic Justice League to write a very short, it's 2 or 3 pages, accessible paper meant for lay people to be able to understand on why these assessment instruments are biased. To your point, Stephen, might they be something that, science can improve upon? Maybe machine learning can help with that in the future, but it would mean starting from new data and not using data that are tainted by all of the other problems with pre-arrest, which leads me to the final point I want to make. The easiest way to handle pretrial justice, or more specifically, pretrial injustices in bail and detention decisions, is to reduce arrests, to not even bring people into the system to begin with. Professor Luna, who spoke to us earlier today, wrote a seminal piece on overcriminalization. Right? We have laws that criminalize things like taking the mattress tags off prematurely, right? We seem to think that everything requires a criminal justice response. And I think what we've learned from the war on drugs is that's not the way to go. So many people who are in trouble are in need of public health interventions, especially for substance abuse disorders. Putting people into the criminal justice system unnecessarily is not a good use of state dollars, taxpayer resources, and it's fundamentally unfair. We can and must do better.
That opens up a whole new panel, I think, for us, but we don't have the time for that. I want to give everyone, Sarah has had to leave, and I know Stephanie also has a deadline. So if either of you want to give a final 1 minute closing remarks about your prognostications for the future of bail reform legislation in the region, and then we can close the session down. If you're still there, Stephanie?
Sure. Yeah. Well, thank you so much for having me. It's really an honor to be here and present with all of you. I think, moving forward, our governor has stated that he would like to call a special session sometime this summer to address the issue with the hope of bringing back all of the stakeholders to the table. So it's not like this is a repeal with no future plan. And I'm hopeful that as we continue talking, that we can really do a good job of vetting the actual issues. There was a lot of misinformation that circulated and fueled the repeal efforts here in Utah this past session. And I think we need to be really honest about what's going on and get to the bottom of that. We can't make good policy off of bad information. And so I'm hopeful that without sort of the pressures and the looming deadline that the general session presented for a lot of us, that we can go back to the drawing board and parse through these issues and craft something that, frankly, my hope is that it resembles a lot of what HB 206 did for our state. We cannot detain people who can't pay. I mean, that's just a system that we can't afford to go back to. So I'll be intimately involved, and I'm happy to be a resource to others who are looking at this issue, others who want to learn more about what's going on in Utah. Feel free to reach out to me either by phone or email. I'm always happy to chat.
Thank you, Stephanie. Carmen?
In doing research and preparation for this panel, I increasingly became frustrated because as I was learning things, it was nowhere to be found in the news. And I say that because this is a conference of journalists. And so what I am going to encourage all of the journalists who are attending to do is to watch a bond docket. They are open to the courts and see how little information is being used to make decisions that ultimately are going to hold most of the people pretrial detention for who knows how long, and not be distracted by the sexy crimes, right? Not be distracted by sex assaults or homicides or, serious drug felonies, right? Because that's not what we're talking about when we're talking about bail reform. We're talking about misdemeanors and low-level felonies and nonviolent crimes. So I really encourage all of you to watch a bond docket and see how that plays out in terms of who's going to be held and who is not going to be held. I'm also going to really encourage the journalists who are attending to look at and I keep using this phrase because I don't know a better way to say it, the non-sexy ways that this is playing out, right? So most of the media in Colorado has been about the ACLU's lawsuits. It hasn't been, right, about those day-to-day impacts, right? The fact that 30 days in jail can cause someone to lose their Social Security benefits. And what does that mean for a family, right? It's right. Khalif Browder is a sexy story because JC became involved, right? And all of that nature. But I carry a caseload right now of about 175 cases. Most of those are lower level felonies. The number of Khalif Browders I have in El Paso County, Colorado are too many to count. And I think if we're talking about bail reform and talking about the role that journalists play, we have to tell those stories, right? One of the things everyone asks me as a public defender is, how can you represent those people? The fact of the matter is, those people are your sisters. They are your mothers. They are the women who cared for you when you were growing up. They are your Uber drivers. They are the people who make your food, right? So when we talk about COVID and bail and all of that thing, we have people who are being held and then they're being released, and people haven't stopped eating. They haven't stopped ordering out. And so when we consider the ways that the virus interacts with that, like, those are the stories that have to be told so people can truly understand the impacts that bail has upon their neighbors and upon their daily lives.
Thank you, Carmen, and thank you all. I want to thank all of you for a really engaging session. We'll have to leave it there. We're going to take a longer break, what we're calling a lunch break, but you don't have to eat lunch, of course. We can't offer you lunch, maybe just to walk around the block, just to stretch your legs. And we'll be back in about 25 minutes. But thank you again, and thanks to all the panelists.